Welcome to the law offices of Chris M. Ingram's Immigration News Show. Today, we ask, is your visa really secure? We would like to thank attorney Chris M. Ingram and staff at the law offices of Chris M. Ingram for their hard work in preparing the research for this show, which draws on a wide variety of news sources from both sides of the aisle, providing a balanced view. Attorney Ingram is also a vocal advocate for the rights and protection of immigration applicants, although our coverage is designed to be nonpartisan. Please don't forget to like, follow, and subscribe to our channel. We are also on Spotify, YouTube, LinkedIn, Facebook, X, Reddit, and Instagram, where we're growing rapidly thanks to our social media team. You can also visit our website on www.breakthroughusa.com. We'd love to see you there. Disclaimer, please note that this presentation should not be intended as legal advice for your specific situation. If you, a friend, or a family member would like a free consultation, you can visit our website at www.breakthroughusa.com and schedule an appointment. We'd love to hear from you and help you if we can. We'd also like to point out that this presentation was created using AI hosts. Okay, let's dive in. So today we are basically conducting an x-ray of the current immigration moment. And it feels like a really necessary look.
Oh, absolutely. It's especially for those of you listening who are professionals, high-skilled workers, particularly in those crucial STEM fields here in the United States.
Right.
You're driven to solve the hardest, most complex problems in science, tech, engineering. You thrive on order, predictability, data-driven outcomes.
And that's exactly where the tension lies, isn't it? It's kind of ironic. The very system that allows you to stay in the U.S. and do that amazing work, the immigration system, is often the least predictable, most complex system you'll ever encounter.
That's it.
Every variable, every court ruling, every little administrative memo, it acts like this high-stakes lever on your future, on your career, on your residency. The margin for error is just so much thinner than it used to be.
That is the core conflict. Our legal team notes that for so many of you, just being well-informed is a professional survival skill.
It's not optional anymore.
No. So our mission today is really to cut through all that noise and give you some clarity. We're going to look at 4 really distinct but fundamentally interconnected stories.
We'll start with something intensely personal, the success story of an immigrant entrepreneur who risked literally everything. And then we're going to zoom all the way out to these big structural policy battles being fought in federal courts.
And the unifying thread here, and this is what you really need to grasp, is that immigration policy isn't some fixed statue in a museum. It's constantly being redrafted.
Right. It's alive.
It is. It's a series of legal, economic, and administrative design choices. And we have to understand these choices are not abstract. They have immediate tangible effects. They shape careers, they determine which research projects get to move forward, and they absolutely influence the stability of families.
So the goal for you, our listener, is really about future-proofing your path, understanding these dynamics, the push from the executive branch, the pull from the judiciary, these individual stories of resilience. That's what allows you to navigate your American chapter with clarity.
And with courage. And I think most importantly, with dignity.
Exactly. We've seen from the research how Orhan Veli built his stability brick by brick. Let's start there. Let's start with that powerful foundation of perseverance and the risks he took.
Okay, so we're beginning with this incredible, hard-won personal breakthrough of Orhan Veli. He's an Azerbaijani-born entrepreneur. And when our legal team first shared the context of displacement that really defined his early years, I realized this is not just a business story.
Not at all. It's a story of profound human resilience, and it's rooted in massive geopolitical upheaval. Veli was born in what was then the Soviet Republic of Azerbaijan. We're talking about the final tumultuous years of the Soviet Union. His family was characterized by this rich, mixed heritage, Russian, Azerbaijani, Armenian.
And as the empire was crumbling, that diverse background, which should be a strength, it became a liability.
A profound liability. They found themselves caught right in the middle of rising ethnic conflict, specifically as attacks against people with Armenian roots just escalated in their city. It became dangerous. So the family had to make this terrifying, sudden decision to flee when Veli was just
6 years old. They had to seek refuge, first in Moscow. That displacement was immediate, but the path to a new life in the U.S., that was anything but quick.
No, the U.S. refugee process is an endurance test.
It really is. Chris and his team detailed Veli's memories of just years of uncertainty. It involved intense health screenings, really detailed psychological evaluations, and continuous background checks on his parents.
And this bureaucratic marathon stretched until he was 11 years old.
11. That's when the final approval finally came through.
Can you just imagine that? 11 years old. The psychological cost of living in limbo for 5 years, always waiting for that final verdict.
It's immense.
Right.
And when they finally arrived in the U.S., the restart required a total sacrifice from his parents.
A huge sacrifice.
Absolutely. His father was a highly respected engineer. He ran his own lab back home. His mother was a trained artist. Despite these advanced degrees, they had to take entry-level jobs in Florida. Anything to provide a stable landing pad.
And Veli absorbed this crucial, almost brutal lesson from that whole experience.
He did. The lesson was that credentials, yeah, they matter. But adaptability, resilience, and just the willingness to restart from zero, that matters so much more than your previous titles. It's the ultimate stress test on character that so many immigrants face when they arrive.
And that stress test, it clearly fueled an incredible drive in him. He adapted, he pushed through the challenges of inner-city high school in Philadelphia.
Which is not easy.
Not at all. He earned a spot at Penn State, and then he secured this highly competitive corporate path through a Morgan Stanley wealth management internship. By the time he was 22, he had multiple job offers. He was on the fast track.
He had built the stability that had been denied to his family for years.
Right.
But this is where the pivot comes in. And it's such a classic entrepreneurial moment, driven by dissatisfaction.
Right.
Despite the clear path, the security of corporate work, Veli just felt restless. He realized the security he'd fought so hard for, it just wasn't enough if he wasn't building something tangible, something that felt directly tied to his own efforts, not just another office grind.
And that restlessness, that led to this enormous high-stakes leap of faith back in 2006.
A huge leap.
He and his father wagered everything they had. They took out a second mortgage on their townhome to buy his first franchise.
And this is something you can probably relate to. This parallels the situation a lot of folks in our STEM audience face when they're thinking about leaving a stable H-1B or L-1 role to join some high-growth, high-risk startup.
Exactly. The stability you worked so hard to get is the very thing you have to risk all over again to pursue higher growth.
And the risk profile for an immigrant entrepreneur is always elevated. It's always higher because failure means more than just a financial hit. It can jeopardize the entire structure of your residency.
Oh, absolutely.
And those early years were just brutal. It shows just how close to the edge so many immigrant-led startups operate. Veli recalls earning only about $4 an hour while working these grueling 18-hour days.
Wow.
The same survival instinct that drove them out of Azerbaijan was now powering a fast food counter.
And then on top of all that came the ultimate external shock, the kind of systemic failure nobody can predict, the 2008 financial crisis.
Right. And that crisis nearly wiped out the small business they had risked the family home on. But instead of quitting, the crisis forced this radical mastery of his operations.
Okay.
Our team highlights how he rebuilt by focusing ruthlessly on lean operations, mastering slim margins, and really disciplined cost control. For example, he stopped outsourcing routine maintenance. He just learned to fix things himself.
He taught himself.
He did. He realized those survival skills weren't just for weathering a storm. They became his competitive edge over rivals who just didn't have that fundamental discipline.
And that experience, that led to his strategic pivot towards Saladworks. By 2012, he was ready to scale.
Ready for the next big risk.
And again, he went neck deep into debt to buy his first Saladworks store, betting on that fast casual model. It's that calculated, persistent risk that really defines his path, and he just focused on operational excellence.
And the compounding growth from those intelligent, persistent decisions is just remarkable. He focused on relentless improvement. Hiring the right people, tightening his systems, being personally present in the stores, and just continuously reinvesting the cash flow.
And that strategy allowed him to expand so rapidly.
It did.
I mean, the scale today really shows that his initial leap paid off dramatically. He now operates 11 Saladworks locations.
11.
Plus one co-branded unit, mostly concentrated in that dense Philadelphia, South Jersey region. And our researchers estimate these units are generating roughly $12 million in revenue in 2024.
$12 million. That is a significant economic footprint and a major, major success story.
It's huge.
But the revenue, that really only tells half the story. The leadership philosophy is the real deep dive insight here.
Yeah.
He consciously builds a company culture that reflects his own values of hard work and inclusion. In one of his stores, his staff was predominantly Spanish-speaking. So he didn't rely on finding a bilingual manager.
He learned Spanish himself.
He learned Spanish himself.
Yeah.
He said, if that means learning a new skill, you have to do it.
Wait, so he actually learned Spanish just to better manage his staff? That level of commitment, it shows he didn't just understand the business model, he understood the human model.
That's it.
They said my EB-1 needed more categories. I can't even dock. What am I gonna do?
I need to find the right lawyer that can navigate me through this crisis. I need my EB-1 so my new life can begin. These lawyers are amazing. They are walking me through every questions, making sure I don't miss a thing. Thanks to the law offices of Chris M. Ingram, I'm cleared to land. But my career is gonna take off.
Houston. He got his visa.
Need help with your visa? Book your free consultation now at www.breakthroughusa.com and let us take care of you.
That's it. It's a core philosophy of removing unnecessary barriers and investing in the dignity of your team.
Yeah.
And he actively looks for ambition in people that other people might overlook because of a language barrier or a lack of formal credentials.
Right.
Our team noted this powerful story of him hiring a woman who couldn't speak English.
Right.
He recognized her drive, he encouraged her training, and he watched her rise to become a general manager.
Right.
He sees his employees not as inputs to maximize profit, but as the community he's helping to build.
And that commitment is clearly visible to others. I mean, the WoWork CEO, Kelly Roddy, praised his strategy, calling Veely more strategic than other top performers.
Specifically highlighting his focus on culture and team motivation.
Right. That external validation really underscores that his success is built on more than just, location scouting or menu pricing.
And the full circle generosity is the final powerful piece of his story. Veely and his Ukrainian wife, Anastasia, they've used their established success and stability to sponsor refugees.
At least 11 people.
At least 11. Creating the exact kind of stable landing pad that he so desperately needed decades ago.
This brings us to the strategic reflection from the legal perspective. Chris and his team analyzed Veely's journey as a powerful blueprint for you, for our audience.
He stresses that this journey shows the American dream is, and I'm quoting here, not a straight line, but a decision to keep going when life says, stop.
That's powerful.
For you, the listener, the immediate takeaway is practical. Setbacks are absolutely not ceilings. They're course corrections. Persistence in the immigration context means not letting a request for evidence, an RFE, derail your spirit.
Or letting a long processing time convince you to just give up on your path.
Or an H-1B lottery loss make you abandon your U.S. career goal.
Yeah.
It's about treating those setbacks, whether they're financial, personal, or administrative, as challenges to be overcome, not as stop signs.
Absolutely. Our attorneys stress that while talent opens the door, getting the visa, getting that initial job,
it is persistent adaptability and, crucially, building community and showing leadership that transforms that initial opportunity into a sustainable long-term future. This is the positive side of the immigration equation. What happens when stability allows for risk-taking and community investment?
Right.
But what happens when the legal system withdraws that stability?
Right. Let's now pivot and look at the legal and structural challenges that often jeopardize that very foundation. So, we've seen the success that stability can yield. Now, let's look at the forces, often invisible, that are actively working to deconstruct that stability for others. The current environment, it feels like watching two powerful constitutional forces just collide.
It really does.
Aggressive enforcement from the executive branch and the courts testing the constitutional boundaries of that power.
And that collision creates extreme volatility, which is the operational environment for every single immigrant in the U.S. right now. Our first flashpoint is Operation Midway Blitz in Chicago.
A stark example.
It's a stark example of expanded interior enforcement and its interaction with the judiciary.
So Operation Midway Blitz describes a sharp expansion of federal enforcement. What exactly did it entail, and why did it escalate all the way to a court case?
It describes a significant increase in federal immigration enforcement activities in Chicago. Our researchers documented operations that involved coordinated raids and street arrests that, and this is the crucial part, began spilling over into residential and community areas.
And that led to protests.
That led to significant community protests and confrontations over the agents' use of force.
The confrontations then led to court action. Federal Judge Sarah Ellis initially issued a restraining order, and it was aimed specifically at limiting the use of force by immigration agents during these raids, right? Including tear gas.
It was. It seemed like a crucial, immediate judicial check on excessive power.
But it was quickly challenged.
And paused. The Seventh Circuit Court of Appeals paused Judge Ellis's order. They agreed with the government's argument that the order impermissibly micromanaged the executive branch's enforcement logistics.
Okay, can you break down that phrase for us? Impermissibly micromanaged. It sounds very technical, and it relates directly to the separation of powers.
It does. So think of the legal system operating on this principle of separation of powers. The executive branch DHS, IC, they're responsible for executing the law. The judiciary, the courts, they're responsible for interpreting the law.
Right.
The Seventh Circuit essentially said, while we can tell the executive what the law is, for example, you have to respect constitutional rights, we cannot tell the enforcement agents how to organize their tactical deployment, what specific equipment to use, or where to stand.
So they saw it as overreach.
They found that the judge's order had the practical effect of trying to enjoin all law enforcement officers within the executive branch, which they saw as too broad a step into executive territory.
So practically speaking, the courts are signaling that when it comes to on-the-ground enforcement tactics, federal agents retain a lot of discretion.
Broad discretion, even when those tactics involve significant community confrontation.
That's the core takeaway.
It is. While the constitutional question about the level of force is still very much alive, the pause on the order means enforcement operations in places like Chicago can pretty much proceed unchanged while the litigation continues. The rules of engagement, for now, remain highly favorable to federal discretion on the ground.
That brings us to our second flashpoint, which is where the judiciary applied a significant break, limiting the expansion of expedited removal.
A very different outcome.
Yeah. The administration attempted to dramatically broaden this fast-track deportation process.
They did. The goal was to apply it far into the interior, miles and miles away from the border, targeting individuals who were unable to conclusively prove they had been continuously present in the U.S. for 2 years or more.
And that would have just exponentially increased the number of people eligible for rapid deportation without fuller court proceedings.
Absolutely.
Why is proving continuous presence for 2 years so difficult, especially for people who might have entered legally years ago?
Because the burden of proof is incredibly high, and it's often impossible to meet perfectly. You have to provide clear documentation for every single period.
Every month?
Every month. Think about a person who entered legally years ago, maybe on a temporary visa, but then lost their job or status. Their I-94 might have expired. They may have old utility bills, but maybe not for every single month, or maybe they stayed with family for a period without any formal documentation. The system places the burden entirely on the individual.
And if they fail to meet that burden,
they are deemed subject to immediate fast-track deportation.
This is where the D.C. Circuit Court stepped in and blocked the expansion.
Correct, and this is a crucial constitutional check. The D.C. Circuit refused to lift the block on that expansion. Their reasoning was crystal clear. Expanding expedited removal carried serious risks of erroneous summary removal.
So they looked at the scope of potential error.
They did. They looked at the possibility of rapidly deporting someone who actually is eligible to stay, and they decided the executive branch had overstepped its statutory and constitutional limits.
It's so interesting. We saw the Seventh Circuit prioritize executive logistical discretion in Chicago, but the D.C. Circuit prioritized due process and preventing grave error in this expedited removal case.
That contrast is a key illustration of the current judicial fight. Really is. This decision keeps a crucial safeguard in place, requiring fuller, fairer procedures for interior removals.
But it's a fluid situation.
Very fluid. Our attorneys note that the administration's merits appeal on this issue is set for December 9, 2025. This means the legal status of expedited removal expansion could shift, and shift quickly after that hearing, which is why vigilance is so crucial.
Our third policy flashpoint involves data sharing, which strikes right at the core of community trust and compliance.
Yeah, this one's a big deal.
This involved the IRS proposing to share taxpayer address data with DHS for deportation purposes.
And this proposal generated massive immediate concern. A federal judge in Washington, D.C., Judge Colleen Collar-Cotelli, blocked the policy. Her rationale focused heavily on the real-world consequences.
Which were?
The fear of deportation was already depressing tax filing rates in immigrant communities. It was risking a massive chilling effect on compliance.
And if people stop filing taxes out of fear, that's a failure for the system, for everyone.
Absolutely. Judge Collar-Cotelli explicitly warned that if the policy continued, plaintiffs could face grave harm, including illegal removal.
This connects directly to you, the listener.
It does. If you are on an H-1B or an O-1, or you have a pending I-485, you are constantly required to maintain meticulous compliance with all U.S. laws, and that includes tax laws.
So if compliance with one system, like tax filing, risks triggering adverse action from another system, deportation enforcement, then trust just evaporates.
It evaporates,
Yeah.
and highly documented individuals become reluctant to provide official, accurate addresses.
Our team highlighted a quote from Nina Olson of the Center for Taxpayer Rights. She emphasized that confidentiality is core to taxpayers' trust in the system.
And this is a crucial point for high-skilled workers. This is not some abstract civics lesson. Your family's confidence in basic systems is affected by these enforcement policies. The policy might seem aimed at undocumented individuals, but the collateral damage affects every immigrant who fears scrutiny.
So let's synthesize these findings. We're seeing a really clear pattern here. The administration is pushing enforcement boundaries
Geographically into cities.
and procedurally through faster deportation mechanisms and broader information sharing.
USCIS is cracking down on visa fraud, and even approved cases are being revoked.
Why was my visa denied? USCIS revoked my approval. At the law offices of Chris M. Ingram, we handle every detail with care. Every form, every fact, every time.
So join us for a free consultation. We do things the right way. Let us take care of you.
And the courts are providing these necessary constitutional pen tests on the most expansive executive moves, but they are not stopping enforcement universally.
No.
So for you, the STEM immigrant, this creates two simultaneous realities. You have a heightened day-to-day enforcement risk in certain places, but you also have continued judicial guardrails against the most sweeping due process cutbacks.
This requires us to dive into what our attorneys termed compliance as a professional skill. What does that look like practically for our audience?
It means treating your immigration path like critical infrastructure in a high-risk environment. You have to assume the margin for error is thinner than it has ever been. This means moving beyond just passive compliance and actually performing quarterly file audits of your own documents.
A quarterly file audit, how would someone even approach that systematically?
Every 3 months, you review your key documents. Do you have physical and digital copies of every single I-94, every visa stamp, every approval notice, every I-797? Have you updated your address with USCIS within 10 days of moving, even if your green card is pending?
That's a big one people miss.
A huge one. Have you meticulously documented all your international trips? If you are relying on travel records or receipts to prove continuous physical presence, you need to organize that stuff now. When a request for evidence, an RFE, or a notice of intent to deny, a NOID, arrives, you need to be able to respond immediately with evidence you've already cataloged.
And what's the practical distinction between an RFE and an NOID in this environment of a thinner margin for error?
That's a critical distinction. An RFE means the officer needs more information to approve the case. A NOID means the officer has already concluded you are ineligible and is giving you one final chance to change their mind.
That sounds much more serious.
In this volatile climate, an NOID is far more dangerous because it signifies the system is leaning heavily toward denial. If you get one, you have to activate your legal team immediately and assume the worst-case scenario. This is where professional compliance means proactive legal engagement.
And this is why our attorneys emphasize that dignity is non-negotiable. It requires steady vigilance, not panic, but intentional professional organization to future-proof your path.
Absolutely. The advice is clear. Stay meticulously documented, get good legal counsel, and never let the fear of volatility shrink your future plans. If you are pursuing a goal, a promotion, a new project, a different visa category, you have to maintain that forward momentum, but with bulletproof compliance powering it every single step of the way.
Our third story provides a look at a judicial intervention that restored a critical lifeline, and it demonstrates that litigation is still a powerful tool for enforcing stability when administrative agencies overstep.
Yes, this one is so important.
It involves Special Immigrant Juvenile Status, or SIJS. What exactly is this classification, and who is it intended to protect?
So SIJS is a humanitarian classification that was created by Congress way back in 1990. It's designed for minors who have survived significant trauma. Specifically, we're talking about abuse, neglect, or abandonment, and who cannot safely reunify with one or both of their parents.
And it requires a specific finding from a state juvenile court.
Exactly.
Yeah.
A state court has to acknowledge that reunification just isn't viable. It's intended to provide a pathway to a green card for youth who have suffered profoundly.
So it offers a path to permanent residence based on humanitarian need, but it's not instantaneous. And that brings us directly to the systemic challenge, the massive visa backlogs.
That is the central vulnerability here. SIJS applicants are placed in the EB-4 visa category, the special immigrant category, which is subject to annual country caps.
Right.
So for countries that generate a large number of applications like India, the Philippines, or significantly in this context, Central American nations, the wait for a visa number to become available can stretch for years.
Sometimes a decade or more.
A decade or more. And during that massive wait, they're growing up. They need to study, work, and just live safely. And that long wait is what the previous protection, deferred action, was designed to bridge.
Okay, so that was the stopgap.
Precisely. USCIS had a previous practice of using deferred action, a specific discretionary protection from deportation to allow SIJS recipients to live, study, and work legally while they were waiting for their visa number to become current. This provided the stability that allows these young people to recover and actually build a life.
But then came the whiplash, the administrative change in 2025. What was the timeline and the mechanism of that reversal by USCIS?
The change was sudden, and it was devastating. USCIS first halted routine consideration of deferred action for SIJS recipients around April of 2025. Then, on June 6, 2025, the policy was formally rescinded.
They just pulled it.
They removed the prior guidance that allowed SIJS youth who were stuck in these backlogs to seek deferred action and file for a work permit under Category C-14.
And the consequences were just devastating. Without deferred action, what exactly did these young people lose?
They lost everything. I mean, they lost eligibility to renew their existing work permits. They faced being placed back into removal proceedings, which means their life was immediately thrown back into total instability.
And worst of all,
they risked losing their chance at a green card entirely if they were deported before a visa number became available. The administrative choice effectively nullified their long-term legal protection that was based on years of trauma and effort.
that sounds like a classic administrative action that just failed to consider the human impact. And this is what led to the legal fight, the class action known as ACR v. Noam.
Yes. Youth and legal service organizations filed the lawsuit in July 2025. Their core argument was based on the Administrative Procedure Act, or the APA.
Can you explain the APA for us briefly?
Sure. The APA is the law that governs how federal agencies develop and issue regulations. It requires agencies to follow procedures and, critically, it prevents them from acting in a way that is arbitrary and capricious.
And the key argument was that the government failed to consider the reliance interests of these youth.
Exactly. And reliance interest means that if the government sets a policy that encourages people to make significant life decisions based on that policy, like enrolling in college, taking out student loans, or getting a stable job, the government can't just unilaterally pull the rug out from under them without acknowledging and justifying the immense harm it causes.
Right.
The lawsuit argued that these young people built their entire adult lives on the expectation that they would be protected while they waited for their visa.
And the court intervention came on November 19th, 2025, with a significant order from U.S. District Judge Eric Committee. What did the order mandate, and what was the judge's focus?
Judge Committee ordered the administration to immediately resume considering deferred action requests under the 2022 framework while the lawsuit proceeds. He essentially stayed the June rescission.
And the court's reasoning was pretty powerful.
It was. The court agreed that the plaintiffs faced irreparable harm without this intervention, specifically pointing to the heightened risk of removal and the loss of work eligibility during these long backlogs. It essentially told the administration, you cannot ignore the fact that people structured their entire lives around a policy you put in place.
It's a powerful victory for stability and due process.
It really is. It shows that even discretionary policies, once they're relied upon, can't be arbitrarily reversed without a thorough explanation. It forces the administration to honor the investment these young adults made in their American futures.
Now, this SIJS case, though it's rooted in a humanitarian category, has crucial relevance for our STEM audience. How does this policy shift signal a broader risk to highly documented workers?
It signals a high scrutiny posture toward all discretionary protections. I mean, if the government is willing to cut off work authorization for a highly sympathetic, vulnerable group, it suggests they're taking a hardline approach to any status that relies on agency discretion.
So this could potentially apply to things like status extensions, H-4EAD extensions for spouses, or even various forms of parole granted to researchers or entrepreneurs.
Exactly. The systemic risk created by backlogs is the central lesson here, because backlogs affect employment-based categories just as severely as they affect EB-4.
Right.
These stopgap protections, like deferred action for SIJS or the ability to expend your H-1B past 6 years while your I-140 is pending, they were vital for maintaining work and study continuity. If those protections are volatile, your entire career runway is threatened.
And the practical impact on the talent pipeline is just undeniable.
Our team emphasizes that many of these SIJS recipients are young adults actively pursuing college degrees or starting careers in colleges and universities. Losing work permits directly impacts their ability to get internships, hold lab roles, pay tuition,
and establish those early career foundations that STEM fields desperately rely on.
Precisely. An interruption in status for this population, or for any population, is an interruption in the American talent pipeline.
So the larger takeaway here is that the courts are still a meaningful check. When immigration agencies reverse course without weighing the human cost and those reliance interests, litigation can, and sometimes does, restore stability.
Status in the U.S. is shaped as much by litigation and procedure as it is by the initial text of the law. You have to monitor not just the laws passed by Congress, but the court rulings that are constantly refining and policing the administrative choices made by the agencies.
So why did you choose the law offices of Chris M. Ingram as your attorney?
Honestly, they made it feel like I was never on my own.
Every time I had a question, someone actually answered. They cared.
We never felt alone. The videos felt like we had someone with us the whole way. Every form, every question, they had a video that explained it.
It made the process so easy.
Our tutorials are designed to get you over the finishing line, and after watching them, you are reassured that you have completed that section correctly.
At the law offices of Chris M. Ingram, our mission is to support you. Our instructional videos will guide you every step of the way. So join us.
Our fourth and final story brings us back to high volatility, focusing on temporary protected status, or TPS, which just reinforces the need for durable strategies.
It really does.
This involves a recent major administrative decision regarding Myanmar nationals. As we've discussed, TPS is a humanitarian shield.
It is a temporary legal shield, and that's the key word. It's designated by DHS when return to a specific country is unsafe due to conflict or disaster. It provides temporary protection from deportation and work authorization, but it is not a direct path to permanent residence.
And the decision announced on November 24th, 2025, was the termination of TPS for nationals of Burma, Myanmar.
Correct. The U.S. Department of Homeland Security, DHS, announced it would terminate the status. This decision was a huge shock to the approximately 4,000 Myanmar nationals who currently rely on that status to live and work here legally.
And the DHS rationale was based on an assessment that conditions have improved sufficiently following the turmoil that began after the 2021 military coup.
That's the official conclusion. DHS Secretary Kristi Noem concluded that Myanmar no longer meets the conditions for the designation. DHS cited steps by Myanmar's military authorities, like ending a state of emergency and planning elections, as evidence of progress.
The secretary said the decision restores TPS to its original status as temporary.
That was the official line.
However, this decision is highly controversial because of the stark contradiction between the DHS assessment and the actual reality on the ground in Myanmar.
The conflict is glaringly evident. While DHS is claiming improvement, our researchers found that other U.S. agencies, specifically the State Department, continued to maintain high travel advisories, warning Americans against travel to Myanmar.
Why?
Due to civil unrest, widespread armed resistance, and persistent instability. This internal contradiction within the U.S. government itself is alarming.
And Human Rights Watch seems to agree with the skepticism regarding the DHS analysis.
We do. John Sifton, Human Rights Watch's Asia Advocacy Director, criticized the government's reasoning sharply. He labeled the U.S. analysis as fantastical.
Fantastic.
Yeah, and that captures the core objection. Rights monitors are arguing that the safety situation simply has not improved in a way that supports the mass return of professionals and families who have been integrated into the U.S. workforce for years.
Okay, so let's focus on the practical consequences for the 4,000 affected professionals in this urgent timeline. What happens on the cliff date of January 26, 2026?
The termination takes effect very quickly. It sets the hard end date as January 26, 2026. After that date, two critical protections end. The temporary shield from deportation expires, and the work authorization tied solely to TPS also expires.
And if the individual hasn't secured another valid status by that date?
They revert to having no protection and no authorization to work.
This creates an immediate high-stakes crisis for professionals in fields like healthcare, engineering, academia.
All of them.
Losing TPS means job loss and just immense pressure to quickly find a new, durable status.
It forces a frantic 60-day sprint. What happens next depends entirely on the individual's immigration posture. Many TPS recipients, especially those in high-skilled roles, have to immediately explore alternative pathways because the termination forces them to find a lawful, durable option or prepare to leave.
What specific alternative pathways must a professional TPS holder urgently explore in that 60-day window?
They need to find a non-temporary anchor, and fast. So first, H-1B. If they are skilled and work for a nonprofit university or research institution, they might qualify for a cap-exempt H-1B.
Which can be filed and processed pretty quickly.
Relatively quickly, yes. This is often the quickest solution if they're in academia or research. Second, EB-2 NIW, the National Interest Waiver.
A self-petition.
A self-petition. If they can demonstrate that their work in engineering, research, or medicine is in the national interest, they can file for a green card without needing an employer sponsor. This is critical because it bypasses the lengthy PIRO-M labor certification process.
And there are other employment-based visas.
Right. O1 for extraordinary ability, L1 for intercompany transfer. If they qualify, they have to gather the evidence immediately. And finally, there's asylum or withholding of removal.
Given the ongoing conflict.
Given the documented dangers of return, many will file for asylum. That provides protection and work authorization while the case is adjudicated, but is a complex, long-term process.
And this planning, it isn't just for the TPS holder. Employers and universities are on the hook, too. They're facing costly talent loss and project disruption.
Absolutely. Employers and universities need to identify their TPS holding employees now. Waiting until January 2026 to start the PRM process or file an H-1B is way too late. It's incredibly risky.
So for valuable team members, labs, engineering teams?
They have to initiate non-immigrant or immigrant petitions immediately to ensure continuity of employment. Failure to plan here is planning to lose essential talent.
This Myanmar decision also fits into a broader, unsettling pattern regarding temporary protections that we've seen recently.
It certainly does. Our attorneys noted that this fits a pattern of efforts to roll back TPS for multiple countries. This reinforces the core operational reality for everyone listening. TPS, like deferred action or other discretionary statuses, is inherently volatile.
It can be switched on and off.
It can be granted, extended, litigated, and terminated on a relatively short timeline by a single administrative choice. You cannot rely on temporary status as a long-term career strategy.
So the crucial advice for the listener, whether you're affected by this termination or you're relying on any other temporary status, is to treat this as a high-priority status review.
That is the strategic imperative. Attorney Chris Ingram stresses the need for a durable strategy that's anchored in a permanent path. That means actively mapping out alternative routes now. Understanding that any status that relies purely on executive discretion can be switched off or litigated into oblivion.
Chris and his team provided a final call to action, acknowledging the immense contribution of those affected.
He recognizes the courage and integrity of TPS holders who have built lives and careers here. His core advice is that whatever policy winds are blowing, their story is not temporary. If you're affected, the most crucial action is to get solid legal guidance, stay organized, and ensure your future is anchored in a durable strategy, not one that can just be switched off.
We've covered 4 intensely detailed stories today, moving from the personal trauma and incredible success of Orhan Veli,
fueled by resilience and stability,
all the way to these high-stakes policy battles over enforcement and temporary protection. Let's synthesize these themes.
The common thread across all 4 stories is this constant struggle over fundamental questions. Who do we recognize as belonging here? How much uncertainty should we expect people to live with? And how do we secure permanence when the rules themselves are constantly shifting.
Vili's journey represents what happens when stability, even hard-won stability through refugee status, allows an individual to take risks, innovate, and reinvest in the community.
Right.
It shows success isn't linear. It's a sequence of pivots, near failures, and small wins that compound over years, fueled by resilience and, crucially, anchored by permanent status.
And the policy stories, the enforcement push, the expedited removal fight, the SIJS ruling, and the Myanmar TPS termination, they show the opposing force, volatility. They demonstrate how quickly the rules can tilt toward risk or protection.
A single judge can restore safety and work eligibility to thousands of vulnerable youth
by enforcing the Administrative Procedure Act.
While a single administrative termination can push thousands of highly productive professionals toward a hard legal cliff.
Exactly.
So for the STEM graduate or professional listening to this, what is the strategic imperative in this volatile landscape?
The message is intentionality. You have to treat your immigration path like critical infrastructure in a highly complex, interconnected system. You have to monitor it, you have to stress test it regularly, and you have to assume that the default setting of the system is not constancy.
That means specific, actionable steps for you, the listener, that go beyond just basic compliance.
You need to seek qualified legal advice early, not when a crisis hits. Conduct those quarterly file audits we talked about. Track the policy shifts relevant to your visa category. Don't just wait for your lawyer to call you.
And build those strong supportive networks with employers and universities.
Yes. Networks that are educated about your status and can help you respond if the landscape changes suddenly, as we saw with the SIJS and TPS reversals. Your employer should know the difference between an H-1B, an O-1, and an EB-2 NIW pathway and be ready to deploy them for you.
And finally, the reflection from Chris and his team brings us back to the human element that underpins this entire system.
He reminds us that your identity is so much more than a category code F1, H1B, TPS, SIJS, EB, whatever. You are a person with skills, relationships, and a future that matters immensely to your field and to the U.S. economy.
The American dream, as we've seen today, isn't a fixed destination. It's a project under constant revision. A project that requires constant effort, legal insight, and strategic maneuvering.
Your job, then, is to stay in that project thoughtfully, legally, and bravely until your story is as complete and hard-won as the stories of entrepreneurial success and judicial resilience we discussed today. That combination of talent, persistence, and proactive planning is what secures your path, regardless of the policy winds.
Thank you so much for being with us today. We hope you gained a lot from this discussion. Please leave us a comment if you can. Additionally, you can support our channel by sharing it with your friends and family, helping us build this community together. Also, follow us on Spotify, YouTube, LinkedIn, Facebook, X, and Instagram, where we're growing rapidly thanks to our social media team. We would also like to thank attorney Chris M. Ingram and his dedicated team once again for researching and preparing this material for our presentation. See you next time on Let's Talk U.S. Immigration. Bye for now.